Hello, this is The Scale of Justice on the network service of the Nigerian Television Authority, and I'm yours on this program, Femi Okeowo. The last few weeks have been quite busy for the nation's judiciary and the justice sector generally. And by the time we are reaching you with this program, about one or two emergency meetings have been held by the National Judicial Council to address continuous emerging embarrassing situation where judges of coordinate jurisdiction are given injunctions which contradict each other. Now, we don't quite have the update of those meetings yet, but on this program for now, we can still reflect on the reasons for those emergency meetings. Let's see why those meetings were summoned in the first place. The Nigerian Television Authority can exclusively confirm that the Chief Justice of Nigeria and Chairman of the National Judicial Council, Justice Ibrahim Tanko Mohammed, has shown concern over the series of conflicting and contradictory ex parte orders of courts on some political leadership matters, which have resulted in embarrassing the nation's judiciary. The summons went to the Chief Judges of Jigawa, Rivers, Kebbi, Anambra, and Cross River States judiciaries for an emergency meeting to brief the Chief Justice of Nigeria on the incessant granting of conflicting ex parte applications by courts of coordinate jurisdiction. The CJN's letter of summons said that an explanation is even more compelling having regard to the earlier NJC's warning to judicial officers to be circumspect in granting ex parte applications. And then we can also sample opinions of lawyers as we did on NTA's flagship program, Good Morning Nigeria, and see what people think about this.
When you talk about the ordinary citizen, it suggests that the not ordinary citizens, or even lawyers, understand what is going on. But I think what is going on is best summed up in the comments made by Honorable Justice Nwosu Iheme of the Court of Appeal, Oka Division, that politicians are going around Nigeria shopping for orders, and that senior lawyers are aiding them in this. And so people want to put the judicial process to the wrong use. And the Lordship said that they want to use the courts to put themselves on the ballot to be able to contest in the election. So your party disqualifies you, you go to a court in Jigawa State, which has nothing to do with the primaries or the election in Anambra, and you get an order compelling INEC. And INEC says, well, because we're a law-abiding institution, we have to respect this court order. And a court in Imo gives another order, and a court in Anambra gives another order. And it's worrisome. When you talk about territorial jurisdiction of court, so a court in Anambra is not supposed to be talking about an election in Kano State, for instance, or even in neighboring Enugu State. But our judges are gradually descending into infamy, giving a wrong impression to the cause that either the wrong persons are now being appointed to the bench, or they allow politicians to induce them, or they are quick because of some inducement, they make orders that no self-respecting judge would. And despite the NJC giving a code of conduct for judges that even ex parte injunctions should not be granted, not only are these ex parte injunctions being granted, they are being granted in far-flung places that have no business. And it becomes worrisome when a court makes an order restraining a person, and another court being aware that there is such an order, or at least being or deemed to be aware of it, saying that they are making an order restoring that person. In other words, seated on an appeal or vacating an order made by another court of coordinate jurisdiction, and it's worrisome. And it makes you know that the politicians are bringing their desperation to spoil the judicial process. And that was how June 12th election was scuttled. The same courts. And we thought we had gradually recovered from that, trying to, to repair the damaged image of the court.
A court order is, whether it's granted in Benin or in Potiskum or in Kafansha or in Oka, you as another judge of coordinate jurisdiction, you are deemed by law to be aware, and you cannot in any way intervene in that matter. But we see senior advocates who, with their pedigree of success and heavy political weight, come to a court and charge heavy money to do an impossible thing, and then they will hail him. Yeah, you were able to stop stop the party convention. That money, millions have been used to spend, to organize.
The judiciary has always been looked upon as those who will give you what God would give an innocent person. And unless we continue to maintain that, that will be the end of that society too. It is unfortunate that things are not working as we were born into. And unless we go back, it will be terrible. Because let me tell you, once there is justice, if the other two arms of the government, executive and legislative arms, do not exist, the society will still exist. Once there is justice. But once there is no justice, even if the other two exist, the society will not exist. That is how bad it is. And something must be done urgently to rectify this anomaly.
Now, it is important to address this issue and nip it in the bud, particularly as politicking and the political season for this country, a general election, fast approaches. With the desperation of politicians, of course, courts will be the place where they run to get orders that would give them a good standing and good positioning for elective positions. And so it is just as well that the Chief Justice of Nigeria has called the various heads of courts and judges to order in this. As the outcome of those meetings come, we will certainly let you know. For now, we also have some other issues which we should be addressing, and it goes with the agenda of government to decongest and reform our correctional centers. The Presidential Committee on the Reformation and Decongestion of Correctional Centers visited Kano. And this time, it was the second visit of the committee to Kano. This time, it brought out another salient issue of how justice can be dispensed quickly, but also how judges should not mix up fines with orders of compensation. We have a story on the visit to Kano, and that will form the main segment of our program, The Scale Today. Rahama Hussaini was a JS1 student in 2014 when she was forcibly married off by her father. 3 days after the marriage, while her husband was attempting to consummate the marriage, a struggle ensued, which was said to have resulted in his death. Rahama has remained in custody since then. While going through the exercise of releasing qualified inmates, the representative of the United Nations Office on Drugs and Crime, UNODC, brought to the attention of the Presidential Committee Rahama's case.
He was sentenced to 10 years. 11 years. He has served 10 years. I think we can consider him. Okay, it's going to okay.
During his courtesy visit, Justice Ishaq Bello raised the issue with the Kano State Governor, Dr. Abdullahi Umar Ganduje, who immediately activated the prerogative of mercy constitutional process to secure a pardon for Rahama.
Your Excellency, we have considered of very importance justice in relation to juvenile. It is very, very obvious that the system has not done much justice to juvenile justice in this country. Across board, these so much complain about the young ones being lumped into adult incarceration centers with the destabilizing consequences of learning more negative behavioral patterns than reforms is something that must be looked into very critically. His Excellency, I'm sure, is not unaware that there are only 3 Boston institutes in the whole country. Knowing how pragmatic Your Excellency is, and with the passion for justice delivery, we thought we should bring this to your notice. I know within no distant time you'll be able to remedy this so that you will put a smile in the faces of these young ones who suffer a lot of neglect.
The Kano State Governor also promised to pay more attention to the juvenile justice system in the state.
Here in Kano, we adopted 2 strategies. One, the Committee on the Prerogative of Mercy, of which we release judiciously inmates twice a year during the Salah break, the Salah Kabir, and then the smaller Salah, as we call it, so that those inmates who gain their freedom will be able to be with their families so that they can also enjoy the Salah festivities. And we also provide some transport money for them. And we also pay the fines imposed on them. And this one is done by the Committee on the Prerogative of Mercy, which they take all other things into consideration, the issue of the offense, the issue of age, the issue of health, and the issue of good behavior. And also by so doing, we are motivating the inmates to be of good behavior because they have seen that some of them who behaved well, they get exit from the correctional home. So that is very, very encouraging. And also you find that we put life into the correctional home. Whenever we go, they stage drama, they dance, they sing. You see, momentarily, you see, you are putting life into them. They will forget that they are confined in that place. They laugh. And sometimes we even offer employment to some of them who gain their freedom. And some of them, you can see talents in them. You can see really talent in them. Another strategy is what we call administration of justice committee, because it is not only stagnation in the prison, lack of releasing the prisoners. There are some cases that are really some who have not been, no judgment has been passed of them. There's no way you can release them. But they constitute a high concentration of the prison. So you can see that the prerogative of mercy will not work on them. So the strategy we adopted is Minister Administration of Justice Committee, where the representative of the correctional facility is there, representative of the judiciary is there, representative of the Ministry of Justice is there, the Commissioner of Police is there, DSS is there. So you can find actually what is wrong. From our own records, we have so many on waiting trial for so long. Why? I think all the stakeholders are there. Sometimes you get somebody on trial for many years because his case file is missing, or the police who is dealing with his case is transferred to another state, and therefore you find, and the man cannot even complain because he doesn't even know what is happening. And you find that he is there for many years not knowing what to do. But if we have all the stakeholders together and there is data, then this one is on trial for so long. What is happening? The man from the judiciary is there. The man from the Commissioner of Police is there. So you can find answers.
19 inmates were released during the exercise through the payment of fines by the Federal Ministry of Justice and various NGOs. 7 others too regained their freedom as a result of old age.
Fines and compensation, they serve different purposes. All right? The fine is a kind of punishment which the state imposes on the convict. Now, the issue of compensation could arise for the purpose of paying some expenses which the victim of the crime might have incurred. Maybe it's just simple conflict and there was a fight, and then the victim sustained some injuries which he had to expend some money from his pocket, all right, for treatment. Now, many a times the judges, after conviction, sentencing, imposition of fines, they make order for a certain amount of money to enable defraying the expenses of that victim of the crime, all right? Or maybe loss of property, destruction, the order compensation. Where the conflict is the misconception that because of the order for compensation, a convict, even after he might have served the period of sentencing, or he had paid the fines, should be continuously remanded in custody because he has not paid compensation. The amount ordered in the compensation, which is wrong. If you notice, fine has a definite period of time, after which, after payment, you go out, or imprisonment terms comes to an end. All right? But when you say he's going to remain there until there is payment of the amount ordered as compensation and he doesn't have it, it's as good as you are saying he's imprisoned for life. All right? And that cannot be constitutional. It can be. There's no penal provision that will allow for that, except if the offense creating the punishment has imposed life imprisonment. Yeah, that is just it.
My Lord, would you wish to recommend to the National Judicial Institute for the training of judges, particularly lower court judges, who are more in the side of doing this error?
Yeah, well, of course, we have said this separately. In fact, one most disturbing situation was, as I had seen in the course of going around, where area court judges ordered for compensation for the purpose of defraying prosecutors their expenses, which cannot be found in any legislation. And for anybody to think that order for compensation will mean remanding that convict ad infinitum, I think that is I'm very sure, not that I think, it's wrong. All right? Compensation, amount ordered in compensation can be realized through enforcement like the way you enforce any civil judgment. That's how it should be. Learning of young ones being lumped in prison along with adults, convicts, and nobody is thinking of, just as they are very much having the passion to build houses, they should be conscious of the fact that the need for Bostal Institute, whereby you separate these young ones, the juvenile from the adults, because at the end of the day, they learn so many things bad. You see, that is why we introduced this readership for reward. And we're happy that the Vice President, along with many other persons with passion for justice, have come in with the relevant books that we require so that it will continue to build the kind of civic thinking, reasoning, so that people will act in consonance with the expectation of the value, expectation of the society.
So far, over 10,000 inmates in correctional centers across the country have been beneficiaries of the intervention of the Presidential Committee. Before we end, let's go to the court and find updates on court issues. Of course, you know that our courts are on recess now. They are on vacation, but there are still vacation judges across the country. And so there are a few issues that are coming up in the various courts. Let's take our segment on this program from the courts.
The Court of Appeal sitting in Abuja has affirmed Valentine Ozigbo as the authentic candidate of the People's Democratic Party (PDP) for the Anambra governorship election. A three-man panel of appellate court justices, led by President of the Court of Appeal, Justice Monica Dongba Memsen, set aside the decision of the Awka High Court, which barred Ozigbo from parading himself as the PDP candidate. The trial court had restrained INEC from accepting Ozigbo as the candidate of the PDP until the final determination of the suit filed by Senator Ugochukwu Ubah to nullify the Congress. The Ikeja Division of the Lagos State High Court has ordered the confiscation of 19.1 billion naira in assets and funds linked to Francis Atuche, the convicted managing director of the defunct bank PHB. The presiding judge, Justice Latifat Okunu, gave the order following an ex parte motion filed by the EFCC. The court ordered the freezing of all bank accounts personally or jointly operated by Mr. Atuche. The Economic and Financial Crimes Commission submitted that the bank MD used 22 firms and 15 persons to launder the money. Mr. Atuche was in June this year sentenced to 6 years imprisonment after he was found guilty of stealing 25 billion naira.
That's how much we have for you on the scale today. We hope issues that have arisen would enlighten us more as to how to fight for our rights and without stepping on other people's rights. We'll see you again with emerging issues in the justice sector. Bye-bye.